Please keep your phones muted while you're listening in. Our speakers, I'm very pleased to introduce Dan Graham and Mike LaCorte. Dan is Vice Chair of the Vinson and Elkins Government Contracts Practice Group. Dan has nearly 2 decades of experience assisting clients on bid protest, Contract Disputes Act appeals, prime and subcontractor disputes, and commercial litigation for clients across many different industry sectors. Especially relevant to today's topics, Dan advises clients on government cost accounting matters, mergers and acquisitions, business restructurings and reorganizations, and internal investigations. Dan has litigated cases before all of the relevant entities: the U.S. Court of Federal Claims, U.S. Court of Appeals for the Federal Circuit, the Government Accountability Office, the Boards of Contract Appeals, and before federal district courts and courts of appeals across the country. Mike LaCorte is one of my partners at the Kenrich Group, which is now part of HKA. Mike is a certified public accountant and a certified valuation analyst, and has significant government contract accounting, auditing, and management consulting experience. This has included regulatory compliance and business system assessments, investigations, litigation support, cost and damage analyses, organizational restructurings, bid protests, due diligence related to mergers and acquisitions, management consulting, and similar engagements. So with that, I want to turn it over to the speakers, especially Dan. Dan, do you want to say a little bit about, to set the stage a little bit more?
Sure, thank you, and thanks for having me, and I'm glad we could put this program together. The purpose of the presentation is really to set the table for companies that are either looking at entering into the federal government contracting market, or may have found themselves in the market either intentionally, unintentionally, and want to better understand what they may have gotten themselves into. And that's not uncommon. Companies may find that they have entered the federal government contracting market through an acquisition, and the target had one or more government contracts. It wasn't a big part of the target's revenue, so it wasn't something that was really closely examined during diligence, but now you've got it, now you've got that contract, and what does that mean for your business? We are not going to get into too much into specific strategies, specific business systems, legal approaches to handling some of the issues we're going to talk about today. The purpose of this presentation is really to provide a very broad survey of what we see in advising our clients is the key differences between doing business with the federal government, a federal government agency, and doing business in the private commercial space. And so we hope coming out of this that you have a better kind of overarching view of what that market looks like. We hope that we've dispelled myths that may have inhibited you from getting into the market, but we hope we've also opened everybody's eyes wide open to some of the real risks and significant differences in this market. Thanks.
So, why, as a company, would you want to get into business with the federal government? A few reasons that we typically see. One, the U.S. federal government's the largest buyer of goods and services in the world, and we're seeing that now in the Corona environment. Even during recessions or economic downturns, the government is still purchasing goods and services. It's not like it just shuts off. The government will still procure. The needs may change, but they will still procure. Also, as a small business, small or disadvantaged business, there are unique opportunities to enter into the federal space where competition is effectively reduced and barriers to entry are lowered for smaller disadvantaged businesses. That's pretty unique to the federal market and dissimilar to the commercial market space where there's special provisions for these small or disadvantaged businesses. There are also benefits to revenue. The U.S. government is a steady customer. The contracting vehicles provide opportunities to recover the cost of running your business. So not just the cost of direct cost of servicing, a contract as an example, but also the cost of overhead and G&A, associated with just operating the business generally. Another benefit from a revenue standpoint would be portfolio diversification. So, I think as folks understand, a well-diversified company, in many ways can be in a stronger position to grow and also withstand, economic downturns, recessions, et cetera. So it is a good portfolio diversification. From a cash flow vantage, there's very low risk of payment default with the government. They're a very steady customer. They typically pay their bills on time. In fact, there are contractual clauses that incentivize heavily the government to pay their bills on time. And associated timely collections of account receivable. So you're not having to effectively foot the bill, so to speak, for late payment of receivables. Typically, with your government contracts, you're going to have good cash flow, low day sale outstanding. Next slide, please.
Yes, and I'll just add that just anytime a company can increase its volume of business, it's going to drive its indirect rates down, and that sometimes is another benefit to the volume of government business.
And Greg and Mike, let me add one thing on top of that I think is relevant to this presentation. So a significant barrier to entry in the federal government market is knowledge. It is the apprehension of all these things that we're going to talk about that appear to be strange, high risk, low reward, all the audit oversight concerns. Those are barriers to entry, and the companies that have gotten comfortable with that, the companies that have understood what those requirements and what those differences really are and adjusted their business systems, their governance and legal strategies to address those risks, they enjoy a barrier to entry that that keeps many of their competitors in the commercial marketplace who just don't want to deal with this out of that market. And stability, one of the key things that we hear from clients about the advantages of the government contracts market is the stability. But stability requires real understanding of the differences and the unique rules and regimes within the government market. If you don't understand that, you're not going to see stability. You're actually going to have significant uncertainty, and your expectations are not going to be aligned with reality. So a big part of this presentation is trying to help folks understand, is this a market that I could get comfortable with and start to explore further.
Interesting. Mike, slide 4.
So just a couple specifics kind of in our current business environment, the COVID-19 environment. So with regards to government contracting, there are significant opportunities to either enter into, for the first time, federal contracting or expand, a company's footprint to the extent they are already doing business with the government due to increased federal spending in response to the pandemic. So as an example, the Coronavirus Aid, Relief, and Economic Security Act, frequently known as the CARES Act, that provided $2.2 trillion in funds to enhance the economy and support national security supply chain initiatives. We have seen contractors that really don't do work with the federal government, get access to contracts that are issued under an emergency to do things like expand hospital capacity or increase production of personal protective equipment. That those opportunities would not exist but for kind of our current business environment. So under CARES specifically, because I think that is the largest government response to date, as it pertains to the COVID-19 pandemic, just some statistics for different departments and the funding that they've received just through that act. So Department of Labor, Health and Human Services, and Education and related agencies, it's about $172 billion. Department of Transportation and Housing, it's another $49 billion approximately. And the Department of Homeland Security, another $46 billion. So a lot of money allotted to these agencies, a lot of new contracting opportunities with those additional funds. And then last, kind of the Defense Production Act. I'm sure folks, at least some folks have heard of the Defense Production Act. The Trump administration has utilized its provisions in some circumstances, but it requires contractors or private businesses to prioritize government contracts for national security purposes over other contracts. And what at least I've heard most about the Defense Production Act and its use in the current environment is the production of medical equipment and supplies, so PPE as an example.
So Dan, do you want to tell us a little bit about some of the differences?
Sure, let's advance to the next slide here. So again, this is really a survey presentation. We're not going to spend too much time on any one of these areas. The goal is to give you as broad an overview of what we see as the differences. And let's start with just the differences we couldn't categorize, the general differences. So let's go to the next slide. And we've tried to take a very pragmatic approach based on what we've heard our clients' biggest surprises, the things they wish they had understood better before they got involved, or conversely, companies that don't want to do business with the federal government, the things that we most often hear from them as the reason why they don't want to get involved. So one of the most obvious concerns is the inability to negotiate many terms and conditions. There is Title 48 of the Code of Federal Regulation is the Federal Acquisition Regulation. And then each federal agency has a supplement to the FAR that's also codified in Title 48. The FAR includes many of the standard terms and conditions that appear in federal government contracts. It also contains extensive guidance to procuring agencies as well as contractors on the application of those terms and conditions and how procurements are conducted and how contracts are administered. But these clauses that appear in the FAR, they have been promulgated through notice and comment rulemaking, and they're not subject to negotiation. In many cases, contracting agencies, contracting officials do not have authority to deviate from these clauses. And if they attempt to, and a contract is signed that deviates from these clauses, in many instances, the deviation will not be enforced. And the clause that should have been in there, the standard regulatory clause that should have been in the contract, will be read into the contract by operation of law. And there's a reason for this. And there are a couple of reasons for this. Number one is the basic accountability issues that an organization as large and diverse as the federal government faces. We talk about agency issues or agency problems with any large organization. Well, the agency problems that the federal government faces are just orders of magnitude beyond what most private commercial entities face. The government has to have a way of controlling all the different employees and officers who have authority to enter into obligations on behalf of the taxpayer. And the way the government does that is standardization and making sure that everybody's literally on the same page by publishing in the Code of Federal Regulations the basic contract terms and conditions for doing business with the federal government. There's also a benefit to standardization because the agency and the federal government can learn from mistakes. It can make changes going forward prospectively that address things that go wrong to make sure that mistakes aren't repeated. Finally, there's transparency and fairness concerns, anti-corruption concerns, by having a published set of contract terms and conditions. It prevents favoritism, it prevents corruption by allowing individual procurements to be structured in favor of an incumbent, in favor of an organization that has some financial relationship with a government agency or a government official. So while at the same time, while the inability to negotiate terms and the differences that we'll talk about between a lot of standard federal government contracting terms and private commercial terms is a significant disincentive to doing business with the federal government. There are benefits to that. And I'll just say one last thing. I mentioned the possibility of regulatory clauses being read into contracts by operation of law, even where the executed contract doesn't contain that term. That's called the Christian doctrine. It's based on a case that was decided many decades ago. But there is a running list of clauses that are in the Federal Acquisition Regulation that will be read into a federal government contract, even if it is intentionally or unintentionally omitted from the signed document. Similarly, the converse of that is clauses that violate statutory regulatory requirements will often be read out of a contract. It's a very fact-intensive inquiry whether that will occur, but it does happen. Let's proceed to the next slide, please. Competition drives a lot of this. Competition really is the bread and butter of the federal procurement system. We rely on competition to ensure transparency and accountability and to guard against favoritism and corruption. We rely on competition to provide value in terms of quality of goods and services, as well as reasonableness of prices. But the result of competition is you have to make sure that everybody's on the same page. And so when an agency issues a solicitation, there are rules in place to prevent companies from deviating from that solicitation, from taking exception to the terms and conditions in the solicitation, and making sure that agencies, when they award contracts, are comparing the offers they've received on an apples to apples basis. So one of the reasons why the federal procurement system doesn't allow for a lot of negotiation of standard terms and conditions is because the way the federal government approaches competition, it relies on and requires an apples to apples comparison of proposals responding to the same terms and conditions. Another benefit of standardized terms is that if you know where to find it, there is a fairly detailed body of case law that interprets these terms, that applies these terms in very specific circumstances. So there actually is more certainty in many cases with these standardized terms than you might have in the private commercial market, where you may be doing business in a state that has not confronted or not interpreted a particular contract term in a particular situation. And you're taking the risk when you do that a court might not enforce something that you worked very hard to negotiate, or might read it differently from the way you have interpreted it. Let's proceed to the next slide, please. When we talk about sources of contract law, it is quite different than private commercial law, which really focuses on the primacy of the contract and the language in the contract as interpreted, as applied, and enforced by state law. With federal procurement law, the federal procurement statutes and regulations are the prime source of federal government contracts law. The contract itself is secondary to procurement statutes, procurement regulations, as I've mentioned. Then you have in the third category, precedential and persuasive interpretations of procurement statutes and regulations and contract language. Because the courts that adjudicate federal contract disputes are different from the courts that typically adjudicate private commercial disputes. There are some deviations in basic approach to contract law. As I said, the court interpreting or resolving a dispute involving a federal government contract is going to look very much to federal procurement statutes and regulations. But when all else fails, most federal courts will say we're going to go to the restatement second of contracts. There's not a lot of reliance on the Uniform Commercial Code in federal government contracts, but the restatement is often seen as a gap filler. But in applying the restatement, the U.S. Court of Federal Claims, Board of Contract Appeals, the Court of Appeals for Federal Circuit, they have adopted some slightly different approaches than what you might see in state courts, in federal district courts, and in the regional circuit courts of appeal at the federal level. We also look at non-procurement statutes. There are often many socioeconomic policies that are incorporated into federal government contracts, labor law policies, anti-discrimination policies, competition and antitrust policies that are derived from other areas of the U.S. Code, other areas of the Code of Federal Regulation that can be very important in interpreting federal government contracts and resolving disputes under federal government contracts. And although it's not binding or precedential, agency policy guidance often comes into play. The agencies are awarding these contracts to further a mission that the agency has. The agency has likely issued substantial guidance and internal rules to address that mission, and oftentimes the contract could be read in light of those internal guidance and non-binding rules. Let's go to the next slide. Authority. Authority is a real pitfall for companies doing business with the federal government for the first time. And frankly, authority issues become a pitfall or remain a pitfall for companies with substantial experience dealing with the federal government. Only a contracting officer can obligate the United States government to the expenditure of funds. And as the procurement system, the federal procurement system has evolved over the years and decades, we've gotten to a place where contracting officers very frequently are organizationally and physically separated from the end users of a good or service that the federal government acquires. The agency may have put all of its contracting officers in one entity or one sub-organization within the agency. The contracting officers may be assigned to different user activities, but still organizationally, physically separate. Part of that is to ensure accountability and transparency. But one of the effects is that the people you deal with as a contractor on a day-to-day basis, your customer, so to speak, is not the individual who can actually agree to changes under the contract or agree to resolve disputes under the contract. And so many, a new contractor and many a current contractor have been burned by relying on statements, representations, promises, guarantees by officials who were not the contracting officer. And these could be 4-star, 3-star generals. They could be senior agency officials with tremendous, tremendous authority within the agency, but they're not a contracting officer. They don't have a warrant to obligate the federal government to expend funds, and therefore contractors cannot rely on them. One of the major differences between doing business with the federal government and doing business with a a private commercial entity is the lack of the concept of a parent authority. In the private world, if ABC Corp, gives Sally Joe a business card that has a fancy title and puts Sally Joe out there in a position where people would assume that and cloaks her in what appears to be the authority to incur obligations and make promises and commitments, that apparent authority can be relied on by other third parties. In doing business with the federal government, there is no such thing as apparent authority. You can have implied authority. We can imply authority based on an official's position, but it's very limited, and we don't have apparent authority. So no matter how reasonable it might seem to you to follow the guidance of a senior agency official, you have to bring it back to the contracting officer. You have to have direction from the contracting officer before you can actually rely on something that would obligate the government to pay money. And the federal crop insurance versus Merrill case, it's an oldie but a goodie, shows how strict that those rules are. Even if you were unaware of the limits on a federal employee, federal official's authority, that's too bad. The officials cannot bind the government beyond their authority, regardless of what the entities, individuals, and companies they deal with might have thought about that authority. Let's go to the next slide.
Yeah, and I'll just add, Dan, vis-a-vis what you've been saying, that I've been involved in so many circumstances where a client will say, the customer loves my product. We get along very well. And then I'll be talking about, well, there's a allegation that you're not complying with some of the applicable regulations. And who is your contracting officer? And what's your relationship with the contracting officer? And they'll be, don't have much of a relationship with the contracting officer, and these compliance issues are what the contracting officer often cares a lot about, and the customer, the user community, may not care so much about. So this is a key issue in government contracts.
Yeah, I'm dealing with this right now, and actually when I get off this call, I've got to write a letter to the Army Contracting Command and the contracting officer on a contract that's being administered by the Army Contract Command. The contract supports the Bradley fighting vehicle, and within the Army there is the PM Bradley, the organization that maintains the Bradley fighting vehicle and coordinates upgrades to that platform. My client has delivered equipment, prototype equipment that is being used to explore some advances to that program. It's been accepted by PM Bradley. This stuff is on Bradley fighting vehicles rolling around in various Army bases across the country. But according to the Army Contract Command, the Army hasn't, quote, accepted that. So this is just a common occurrence where the contracting officials say it doesn't matter what the user organization that the customer has done or told you, it's not accepted, and we're not paying for it until contracting officer's organization has accepted and the contracting officer agrees that it's compliant and ready for payment. Let's go on to the next slide. So very similar to the authority limits are limits on appropriations. So the Constitution creates a structure where only Congress can appropriate funds, the power of the purse, as we call it. And it's a very important check and balance on executive authority. And it's something that comes up in federal procurement quite frequently. Executive agencies cannot spend money, cannot spend appropriated funds. Well, first, they can't enter into obligations generally without an appropriation, but then they can't spend appropriated funds for a purpose or a period that is different from what Congress has appropriated money for. And generally, we talk about time and purpose limitations on appropriations. the purpose limitations are fairly self-explanatory. In any appropriation, Congress will say we are appropriating, $10 million for X. X may leave some wiggle room, some discretion on the part of the agency receiving the appropriation to apply that money to different paths to get to X, but it can't spend that money on Y. And so you can oftentimes understand the scope of an appropriation just by reading the language. And then as the appropriation is assigned by the agency to various agency level buckets of money, there are further definitions on what the money can and can't be used for. Time limitations on appropriations come up frequently because most appropriations are for a single fiscal year. There are no-year appropriations, such as appropriations for the Medicare Trust or for Social Security, but the vast majority of federal procurement dollars are spent using annual appropriations. What that means is the agency who has issued a solicitation for a 5-year contract doesn't actually have the money to spend on years 2, 3, 4, and 5. It may not even have the money to spend yet on the base year, but the contract is going to be structured so that there is a base year, which will almost certainly be a year or less, followed by a series of 1-year options. If there aren't appropriations sufficient to cover the base year, the contract will include an availability of funds clause that basically says, we're signing a contract, but it's not a contract, and I have absolutely no obligation unless and until Congress appropriates money for it. Companies that have not done business with the federal government or a state or local government routinely think that that's crazy. What's the purpose of signing a contract if you're not ready to commit to funding it? Well, it's the appropriation cycle. And as many of you are aware or might be aware, for many years, we have been unable in Congress to agree on annual appropriations. And we've been operating through continuing resolutions, these ad hoc continuing resolutions in order to fund the government. And on a couple of instances, we've not even been able to agree to continuing resolutions, and we've had funding lapses, quote, shutdowns. That's very disruptive to companies doing business with the government. Which is already requires a lot of advanced planning to understand, okay, I have a 5-year contract, it's funded through the next 4 months, the next 5 months. I've got to be very aware of where my customer is on, and when I say customer here, I'm talking about the end user who has been appropriated the funds. The contracting officers manage the appropriations, but they're not the recipient of the appropriation. I've got to be very aware and cognizant of how much money does my customer have, when are they getting more money, and that comes into play when we talk about modifications to contracts. It comes into play when we talk about changes that have been made to contracts, disputes that have arisen. It's always in the backdrop. Is there appropriated funds sufficient to cover what the contract says I'm due and payable, or what I think I'm due and payable based on something that's happened that's deviated from the contract?
Yeah. And Dan, it's my impression that this information on the appropriations is publicly available. A person can figure this out. It's just complex, and you have to know you have to understand the process that you've just described.
That's exactly right. It is publicly available. You have to know where to find it. And if you look at a lot of the larger government contractors, they have internal capabilities, legislative affairs, government affairs capabilities, who spend a lot of time making sure they understand this and making sure they understand where their customers' money is coming from. It's not to say that you have to have a government affairs, legislative affairs organization. If you ever want to do business with the government, you don't. There are many very, very successful contractors who don't have that capability in-house. But they just have to understand where their customer is getting their money from.
Right. And so many times I think people hear government affairs and they think lobbyist, someone trying to influence the process. And you're pointing out, no, that's not the case.
Right.
Just understanding the appropriation cycle and what's been appropriated and what hasn't.
Yes. Let's move to the next slide. Mike, I think you're taking over here.
Yeah, Mike, you want to tell us about contract closeout?
Yep, I've got a little bit of lag. There we go. I didn't realize it was up. So another kind of general difference between government contracting and commercial contracting is a formal process to close out your contract. I'd say, just generally speaking, in commercial contracting, you deliver the goods or service that are stipulated in the contract, and you get paid, and your obligations are over. That is not true, not necessarily true in the context of government contracting. So there's a formal process stipulated in FAR 4.8 for procedures to close out your contracts. And you close out a federal contract when you've met all the terms and conditions of the contract, all your administrative actions have been completed, any and all disputes have been settled, and final payment has been made. That's when your contract is officially closed with the government. There are various methods to close a contract. So contracts using something called simplified acquisition procedures. At a high level, I'd say that simplified acquisition procedures are kind of what they sound like. They're a streamlined method to acquire goods and services. Generally speaking, applicable to lower dollar type procurements. In FAR 4.8, there's kind of a rule of thumb or preference is probably a better way to say it, that when you can, the simplified acquisition procedures should be considered closed when your contracting officer receives evidence of receipt of property and final payment. That is less arduous than other types of closeout. Another kind of difference, and we'll get into different types of contracts a bit later in the webinar, but there are time standards stipulated in FAR 4.8 that are different for contract closeout depending on the contract type. So there are different types of contracts in federal contracting, so cost reimbursement, time and materials, firm fixed price, sometimes called lump sum. There are many different types of contracts, again, that we'll get into in a little bit in a couple of slides here, but your time requirements to close a contract differ depending on your contract type. Also, there's a process called quick closeout, again, where there's not a lot of money in dispute, or not in dispute, but at risk for a particular contract. There are procedures to close out a contract that are less arduous than what is stipulated in FAR 4.8. We can please we move to the next slide.
Well, and I'll just point out, I know you're going to, you and I've talked about this many times, but so many clients of ours, they bill and get paid by their government customer very quickly. So they might get paid in 2 weeks. I mean, and so they're loving the cash flow, and they're everything's going well. But they don't realize that those in many types of contracts, those payments are interim payments until you get to close out. So you could complete performance, be in the process of closing out the contract years later, be audited, and some cost disallowed. And then the contractor's like, what gives? I was paid. No one ever objected. Well, they didn't have to until they get to closeout.
Agreed. And I'd add one more thing. I mean, the closeout process, kind of the elongation of that timeline to officially close out a contract, effectively extends the timeline that a particular contractor is required to be in compliance. It also extends the timeline that a contractor is required to maintain certain records. So, I mean, there is kind of a cost associated with this longer timeline, in addition to, just what Greg had just alluded to, potential disallowed costs or adjustments, other types of adjustments that arise purely from the contract close. So just a little bit more detail on kind of, and again, the different contract types, or many of them are listed here, but just to give you a flavor for the different time frames associated with closing out particular contract types. So the quickest time frame would be 6 months. And again, this is, I'd call standard contract close, so not the quick close procedures that I referenced before in the prior slide as an example. But your firm fixed price contracts, where the contract price is not generally subject to any kind of negotiation based on your cost experience, that's a 6-month time frame. What are called flexibly priced contracts, so where the cost incurred in performance of the contract actually may implicate contract price. That generally tends to be the longest time frame because there's information typically that is needed from the government. So your indirect cost rates need to be settled with the government before you can close out on a cost reimbursement contract, as an example. Also, because there's a lot of compliance risk associated with flexibly priced contracts, especially in comparison to something like a firm fixed price contract. There's more to do to close out the contract than there would be for firm fixed price. And then you have this kind of in-between 20-month period for fixed price redetermination type contracts. So that's fixed price where there can be a redetermination based on certain conditions, either being met or not met, where the price may be adjusted. And there's a fixed price with economic price adjustment, which is similar, except that your price adjustment for that fixed price is typically linked to some kind of index, so a published index. So the 20-month time period associated with those contracts for closeout, I think really encapsulates kind of the difference in risk profile between the contracts. So if you look at these timeframes here, 6 months firm fixed price, I think lowest type of risk from the vantage of the government. 36 months flexibly priced contracts, kind of the highest risk for the government. And then you kind of have these contracts that are in between, which are more risk than firm fixed price, but kind of less risk than your pure flexibly priced contracts. If you would proceed to the next slide, please. So another, I'd say, big difference is how you get paid, or can be how you get paid in comparison to kind of a commercial agreement. So in government contracting, one method for payment is something called progress payments based on cost. And effectively what it is it's almost like a fraction of the cost that you've incurred compared to the total cost that you anticipate incurring. You multiply that fraction by your contract price and come up with a number, and you can get up to 80% of your costs, or up to 80% of the quote unquote progress, based on that ratio. And just as kind of a current events note, Department of Defense, I believe, has increased these percentages to 90%, in some case 95%. I've got 80 and 80% here. That is the rule per the FAR. There's a Department of Defense deviation that's currently in play due to COVID. But the concept of not getting paid based on deliverables, and instead measuring progress in this way, I'd say it's pretty unique. It is applicable only to your fixed price type contracts. In certain circumstances, the general kind of fraction type approach that I described, you may be able to deviate from that, but generally speaking, you're looking at your costs incurred versus the costs that you're forecasting. But again, this type of payment mechanism is pretty unique to government contracting. It is new to a lot of contractors, and frankly, if it's not well understood, can create problems in the form of you're not measuring progress correctly. As an example, that means that could possibly mean that you've made a claim for payment that you maybe shouldn't have. And Dan later on will talk about some of the kind of risks associated with making mistakes in that vein, making requests for payments that you're not otherwise due, or making a mistake for a payment, overbilling the government.
Yeah, I like to think of these as, go ahead, Dan. Yeah, I like to think of these as being loans, financing payments. I think they're more akin to financing payments than they are to payments for delivered service.
I would agree. Yeah, I mean, it's so a good example could be, the government has hired me to build a bridge. Me as a contractor, I don't want to get paid only at the time that I build the entire bridge, because I'm floating a lot of cash at that time, and I'm incurring financing expenses. So a method potentially to not have to incur all of those financing, or not bear all the costs of financing the project in its entirety. Maybe you measure progress on a project like that. So as opposed to getting paid, 100% when you build the bridge, maybe when you build, 30% of the bridge as measured, I've incurred 30% of the costs that I forecasted to incur for the entire project. That's a method to get paid, and as Greg said, it is kind of a mechanism for financing. Next slide, please. Now, another method for payment, which I'd say is more akin to kind of the commercial marketplace, is what's called performance-based payments. This payment methodology is preferred by the government. In performance-based payments really are based on acceptance of specified performance criteria. The government accepting that you have performed on specific criteria. So, as an example, performance-based payment may be, I have been hired to develop, or to build 100 ships. Maybe the performance there is at the completion of the ship, or airplanes, however you want to think of that. So the major difference here is that payment under this set of rules would be based on defined performance criteria, as opposed to measuring performance based on cost that you've incurred versus the total cost that you've are expecting to incur on the entire project. Similar to progress-based payments, this is going to apply to fixed price contracts. And some of the performance metrics that can underpin these types of payments include, an objective quantifiable method. So in my example, potentially that could be number of airplanes. I completed one airplane. I want to get paid for my one airplane, even though I have been hired to build 100 airplanes. So each airplane that I build, I get paid for. Accomplishment is a defined event. I've hit some type of contractual milestone. So if I'm building a building, there's several stages in building my building. Maybe a milestone might be, once I've poured cement for the foundation of the building, I get some amount of payment, or some other type of milestone there. And then there's this general other quantifiable measures of results. So, that's kind of a little bit more open for interpretation. But again, big picture, a couple different typical ways to get paid really under your fixed price contracts, which for a lot of companies that enter into the federal market space for the first time, fixed price contracts can be appealing because there's less compliance requirements typically associated with those types of contracts, and they're lower risks for the government. So, again, two big ways to get paid under those contracts: progress-based and performance-based, where performance is going to be most similar to what you'd expect in the commercial marketplace. Next slide, please. So as I had said previously, there are a lot of different types of contracts in vehicles, ordering vehicles that are somewhat unique to government contracting. I'd say, just based on my personal experience working with commercial customers, those contractual arrangements tend to be pretty close or align, very neatly with a firm fixed price type of relationship. I negotiate with my customer to perform a service or provide a good at a specified price. that type of arrangement does exist in government contracting. It's actually, I think, preferred from the vantage of the government because it's lower risk. But there's all these other types of contractual arrangements that are, while not 100% unique to the federal space, that they are less common in what I would say in the commercial marketplace. So starting kind of from your risk profile here, lowest risk, and this is from the vantage of the government, lowest risk type contract is going to be the firm fixed price. So in that type of arrangement, the price is going to be set. It's predetermined. It can be negotiated, but I think the point here is it's generally not subject to negotiation, or it's subject to adjustment based on your cost experience or other types of experience. In those types of contracts, typically you're typically obligated to perform on the contract, even if you've underbid the contract or you've mismanaged under the contract and you're losing money. Typically under those types of contracts, you're obligated to deliver what you've been hired for. So in that vein, the contractor is assuming the risks for controlling costs to ensure that they're profitable. Conversely, the fixed price type of contract arrangement with the government generally, I'd say, would provide the greatest opportunity for higher margins. As we talk more about cost reimbursement contracts in just a minute or two here, the amount of profit or what is called fee in government contracting, but it's akin to a profit, is actually controlled or limited by regulation, whereas firm fixed price, the strict limitations that would be applicable to cost reimbursement work are not there, which provides an opportunity for a contractor to, and again, generally speaking, earn a greater profit under a firm fixed price type arrangement than they otherwise would be afforded under a cost reimbursement type arrangement. Another kind of concept that we'll go through later is this concept of commercial item acquisitions with contracting with the government. So in government contracting, there's an entire section of the FAR Part 12 that speaks to commercial item acquisitions. And the commercial items are kind of what they sound like, goods and services that are available, commercially available. It's more complex than that because the definition of commercial can include things that go beyond, it's just generally available commercially, or I have a market or a list price available and I offer these same goods or services to the government. But again, generally speaking, your commercial item type contracts would be for goods or services that are sold not just to the federal government, but within the commercial marketplace as well. And as it pertains to commercial item contracts, firm fixed price is a very typical contractual arrangement there. And the last thing I'd say about firm fixed price, as really opposed to other types of contracts, firm fixed price is appropriate for a contract type when the good or service being provided is typical. It's not very unique and specific. It's something that's been done before, or producing a phone, for example, my iPhone here. That's something that I would expect would be under firm fixed price government if it was contracted with the government. The phones are produced, they're commercially available. There's not really a lot of uniqueness and specificity. You're going to have a kind of an off-the-shelf product. So, from the government's perspective, me as a producer, if I'm producing the phones, I should have a pretty good handle on the types of costs that go into producing the phones, and therefore I should have a pretty good handle on what a fair price would be to charge the government, and shouldn't need to change my prices later based on cost experience. So another type of contract with the government is cost reimbursement. This is really a lot different than what I'd see in the commercial marketplace. So cost reimbursement vehicles, or contracts, they reimburse contractors for what's called allowable and reasonable costs incurred. As we will get into later a little bit more in the concept of unallowable versus allowable costs, but high level, allowable costs are costs that the government will pay for under public, because of public policy, or they don't contravene public policy. So me as a contractor, if I want to get paid under my cost reimbursement vehicle, I need to track my allowable costs. This type of contractual arrangement doesn't provide a high incentive for me as a contractor to control my costs. So the government has a lot of compliance requirements that are embedded into these types of contracts that help manage the risks for uncontrolled costs. These types of contracts, as opposed to fixed price, they have a really high administrative and compliance burden. Firm fixed price contracts generally don't have that same type of compliance burden because, again, the contractor kind of assumes a lot more risk under firm fixed price than compared to cost reimbursement, where the risk really is borne by the government. Another type of ordering vehicles is what's called indefinite delivery, indefinite quantity type contracts. It's a vehicle. So under this type of arrangement, the contractor will be awarded, an ordering schedule. It's a contract with a minimum value, a couple $1,000, maybe $2,000-$3,000. But that ordering schedule itself doesn't really have a lot of value. The value under these types of arrangements really emanate from task orders that are issued, that you're only eligible to receive the task orders if you have the ordering schedule themselves. So, kind of a nuanced concept in government contracting, I could be awarded a quote unquote $1 billion IDIQ contract. But then, at the end of the day, I may not be awarded any task orders under that contract. So the actual value that is derived from the contract may be close to zero in that case. So there's a few different types of IDIQ for short vehicles. So you have your definite quantity. It's a delivery of a definite quantity of supplies or services for a fixed period. Indefinite quantity is a delivery of an indefinite quantity of supplies or services for a fixed period. And then indefinite quantity also would include minimum and maximum quantity limits typically. So there can be a lot of variability in the ultimate benefit derived from an IDIQ. And I know in the context of like mergers and acquisitions for companies that hold a high volume of IDIQ contracts, it can be a little bit hard to value those types of contracts because you don't really have it. You may not have a great handle on task orders that would be issued under the IDIQ. Next slide, please. There's a couple more, contract types and vehicles. There's another one, government-wide acquisition contracts. We call them GWACs. These are pre-competed multiple award IDIQ contracts. They're pretty specific purpose, used to provide IT solutions. So think design, software engineering, information assurance, enterprise architecture type solutions. So it's a kind of a subset, if you will, of an IDIQ, kind of specific to IT, GWACs. And then last, I previously talked about FAR Part 12 for your commercial item type contracts. So the General Services Administration maintains these schedules, federal supply schedules, and there's multiple award schedules. Each schedule that is maintained by the GSA pertains to kind of a different type of service offering. So, contractors, you may have heard the term trying to get on schedule. There's a process to be an eligible service provider underneath one of these schedules. So for example, there's an IT schedule. So contractors that want to provide IT services to the government on a commercial basis, they try to get on the IT schedule. Once they're on that schedule, other government agencies can look at their pricing and what they're offering, and it's almost like purchase, like it's purchasing in a manner that's very similar to like catalog. Hey, I see a catalog full of service providers, maybe I'm looking for a plumber and I see 6 different plumbers and they all publish their price lists for plumbing services. The supply schedule is kind of similar in that manner, where you say, I need IT services. I look at the GSA schedule, I see, all these different service providers. I can see their prices per labor category, and I can decide based on the schedule, those prices. I can negotiate those prices, but those prices generally kind of represent a maximum price that I may pay. Me as the government, I can negotiate downwards from there, but kind of takes a lot of the mystery out of pricing, and it provides for a pretty streamlined method for the government to buy goods and services from contractors. And next slide.
Dan, you want to talk about penalties a little bit? Explain
Sure. So this is not intended to be a scary slide, but I guess it is. It is certainly the case that there are civil, criminal, administrative penalties that can be imposed on contractors that cannot be imposed on private commercial organizations. It's certainly also the case that fraud is fraud and crimes are crimes, and there are lots of ways to get in trouble with the law, civil, criminal, otherwise, as a private commercial entity. One of the criminal statutes listed here is the the Mail and Wire Fraud Act. That is often a statute that's used to prosecute government contractors who have engaged in fraud, but it's not limited to government contracts. Other statutes here do involve some transaction with the government, the Criminal False Claims Act and the Civil False Claims Act. And we'll talk about the Civil False Claims Act more in a bit. But each of these statutes is a tool that the government, primarily the Justice Department, will use to protect the government's interest from being victimized by unscrupulous contractors. And understanding what these rules are, how they differ from the criminal compliance obligations of a typical business is a big part of being a compliant government contractor. For example, the Procurement Integrity Act and the Anti-Kickback Act. These are both criminal statutes. They have civil and administrative penalties as well, but they regulate a specific perceived wrong that occurs in federal contracting. The Anti-Kickback Act prohibits prime contractors from receiving payment, things of value, from subcontractors in exchange for awarding subcontracts. And the concern there is that those kickbacks, they prevent subcontracting being done on merit and best value bases, but those kickbacks then find a way to get baked into the price that the prime contractor charges to the government. And so there is a specific statute that prohibits the payment, solicitation, receipt of kickbacks, and says what happens when a kickback is identified. The Procurement Integrity Act, this is a industrial espionage statute that is specific to federal procurement. It also has an element that deals with hiring former government employees who were involved in procurement. So it's designed to address a couple of different things that are perceived to compromise the integrity of the federal procurement process. And they don't really, there are industrial espionage laws that apply to private commercial organizations, but these are very different from, the PIA is very different from those laws. And so something very important to understand. Coming down to the administrative penalties, there is a suspension and debarment regime where companies who are deemed to be non-responsible because they have engaged in wrongdoing, they have repeatedly failed or failed in a very significant instance to fulfill their responsibilities to the federal government, they can be excluded from consideration for future awards. A suspension is a temporary debarment while the underlying grounds for debarment are explored. So those are your quintessential administrative penalties in the contracting space. You can also have penalties for charging the government amounts that under the Federal Acquisition Regulation or under a governing statute, you are prohibited from charging the government. Let's go to the next slide and talk a little bit more about the False Claims Act, because the SCA.
Yeah, let me comment before. Sure. This is a scary list. I mean, no question. I mean, as you point out at the very bottom, the above list is not exhaustive, and you haven't even talked about the details of the False Claims Act, which is coming next.
Yeah, so this is the government's primary tool for combating perceived fraud in the government contracting market. Importantly, it doesn't require fraud in the ordinary common law sense. There are a number of statutes that do require a showing of intent to deceive, intent to mislead the government. The government can also, the Major Fraud Act, for example, the government can also bring common law civil fraud claims. The False Claims Act is not a fraud statute in that sense, although it's oftentimes referred to as an anti-fraud statute. It prohibits, and I've listed the elements here, there are a number of different things that the False Claims Act prohibits. First is knowingly presenting, causing to be presented a material false or fraudulent claim for payment or approval. That's kind of the paradigm violation of the False Claims Act. You submitted a claim for payment that was false. It requires that the falsity be known, but it doesn't require intent to deceive. There's a materiality element in here, but materiality is often applied differently from the way that materiality is applied in determining common law fraud. So the SCA is very different, or not very, it is different and significantly different from the fraud rules that most companies deal with. The SCA also punishes the use of false or fraudulent records in support of getting a claim paid. And then there are what are called reverse false claims, which are using false records or statements to avoid having to give money back to the government. Every year, the Department of Justice publishes its recoveries under the False Claims Act. It's averaged about $2.5 to $3 billion over the last 15 years. The vast majority of that is actually in the healthcare space. So these are claims submitted against the Medicare, Medicaid, TRICARE, and VA health system programs. That's a big chunk of it. But the remainder are false claims submitted by the government contractors. Let's go to the next slide. One of the very unique things about the False Claims Act is the ability of what are called qui tam relators. Qui tam literally means in the name of the king. This is a mechanism by which whistleblowers, and these can be former employees of a contractor, can include former officers and directors of the contractor in some instance, or they could be third parties who are external to a contractor organization. They can file a claim or an action under the False Claims Act in the name of the U.S. government against a contractor, against a defendant, alleging a violation of the False Claims Act. The government then has the ability to intervene in that case and take over the prosecution of that case, and the relator will receive a share of any settlement that the government obtains. Or if the government chooses not to intervene, the relator can proceed to prosecute the case on its own, and if ultimately successful, receive an even larger share of any recovery. The FCA is a civil statute. There is a criminal FCA, and we gave you the site on the prior side. The civil FCA, and what most people refer to when they talk about the False Claims Act, is a civil statute, but the penalties are very severe and almost quasi-criminal in nature. First off, the FCA provides for treble damages, 3 times actual damages. Alternatively, the FCA provides for civil penalties that are calculated on a per claim basis. And so the government has really 2 ways, or whistleblowers, qui tam relators have 2 ways to recover. One is to take the loss to the government and multiply it by 3. The other, and this is happens more frequently in high volume fraud, high volume false claims, but where each claim is a relatively low dollar amount, is to claim the civil penalties. And that happens very frequently in the healthcare context, where providers, doctors, hospitals are submitting thousands, sometimes tens of thousands of very small claims, each of which are false. And when these penalties are applied, the total value of the penalty can very quickly become much, much more than 3 times the actual damage of the government. Let's go on to the next slide. And all of this is to say that contractors, perhaps more so than private commercial entities, really do need a very robust internal compliance program, because the consequences of non-compliance are increased relative to the commercial marketplace. You might get sued under a private commercial contract for defrauding your business partner. And if it rises to the level of criminal fraud, district Commonwealth's attorney or a U.S. attorney, federal U.S. attorney, might indict you for crime. But there isn't something that comes close to what the False Claims Act does in terms of the magnitude of the civil exposure that you might be subject to. And there also isn't a mechanism to incentivize individuals within your organization and outside of your organization to ferret out fraud on their own and prosecute that fraud in the government's name, in your business partner's name. So Mike LaCorte has alluded to the difference between commercial and non-commercial contracts. We spent a lot of time trying to figure out where this slide goes in the deck. Maybe it should have come earlier, but this is a big distinction in federal government contracting. A lot of what we've talked about for many companies looking at doing business with the federal government, sometime around slide 17 or 18, they'd say, thanks, no thanks. I'm fine with the business I'm doing now. Yes, there's potentially more revenue to be had by entering the federal government market, but it's just not worth the headache. It's just not worth the compliance risk, and it's not worth the cost of the business systems and internal controls that I would have to develop in order to get comfortable with that risk. The government in paper
articles and the DOJ press releases and so on and so forth.
I'm sorry?
Oh, I was just adding to the list of, there's also, the possibility of negative press releases by the Department of Justice, for example, or other entities like that. And that's just, that's such an impact, a potential impact on the company.
Yeah, that's very true. So the Department of Justice loves to publicize their recoveries under the False Claims Act. So settling with the government, does not give you it might give you finality for that claim, but you cannot agree with the government, or it is exceedingly rare that the government will agree not to issue a public press release that publicizes exactly what they accused you of, or what the whistleblower accused you of, and exactly what you paid to settle it. So that is oftentimes a disincentive to settling, but it's also something that carries a fair amount of stigma for a fair amount of time after the settlement. So coming back to commercial versus non-commercial contracts, beginning in the early 90s, the government recognized that its way of doing business and all these rules that we've been talking about for some time now was a disincentive to many companies to participate in the federal market. The government also realized that some of these rules were just inefficient and potentially unnecessary. And so the government began what has been a several decades long process that continues to evolve to this day of treating commercial items, goods, services that are sold in substantial quantities in the non-government market, treating those differently from non-commercial items. And when commercial items are being acquired, assuming as the default that those items can be purchased by the government, generally speaking, on the same terms and conditions that they are purchased and acquired in the private commercial market. So that there are a tremendous number of exceptions to that. First off, there are certain rules that we've talked about that apply equally to commercial and non-commercial items, and they just don't go away. So all of the civil, criminal, administrative penalties we just discussed. Fraud against the government is fraud against the government. False claims against the government are false claims against the government, regardless of whether it's a commercial or a non-commercial item contract. Issues about the authority of government personnel, the availability of appropriations, these are always issues, regardless of whether a contract is for a commercial item or a non-commercial item. Sometimes the government, and there are other statutory regulatory obligations that apply to procurements, regardless of whether they are for commercial item or non-commercial item goods and services. However, there are quite a few differences, and the agencies can kind of throttle up and throttle down the degree to which it imposes traditional government contracting rules on commercial item purchases. What the Federal Acquisition Streamlining Act does is it says, okay, start from a default assumption that if you're buying something that is a commercial item, look first to the terms and conditions on which those commercial items are typically bought and sold in the commercial marketplace, and then decide, do you need federal government? Do you need something different? It may be that you have to ask for a different term because there's a statute that requires it. It may be that there's something specific about a particular acquisition, a particular agency, and a particular need that it requires a non-standard commercial term, but it sets commercial marketplace terms as the default. There is an entire part of the Federal Acquisition Regulation, FAR Part 12, that deals with commercial item acquisitions. There's a different set of clauses for commercial item contracts, and these clauses have been, an effort has been made to try to more closely resemble the way goods and services are bought in the commercial market. An example, we're going to talk about unilateral changes in a moment. Unilateral changes are an aspect of federal government contracting that really are alien to a lot of private commercial entities. That the notion that one party to the contract can just change what the contract requires unilaterally without having to negotiate a modification or amendment to the contract. Under commercial item contracts, the government doesn't have the authority to unilaterally change the contract. Contract changes have to be through bilateral amendment. So there are important differences. And for a lot of companies looking at ways to get into the federal government market without jumping in on the deep end and really dealing with the compliance issues that come with a large cost reimbursement contract or a research and development contract or something like that. Commercial item acquisition is really an invitation by the government to get in on the shallow end, to get in on terms and conditions that are supposed to be more familiar to what you've seen in the commercial market. Let's go ahead to the next slide. Okay. Strict versus substantial performance. This is another difference between federal government contracting and the common law of contracts. There really is no concept of substantial performance, that good enough is good enough. The rule in federal contracting, and it's the rule whether it's commercial or non-commercial item contracting, is strict performance. The government is entitled to get exactly what it bargained for. There is a limited concept in federal government contracting that is sometimes referred to as substantial performance, but it's really not. It's the better phrase is substantial. The phrase that's actually used in the cases is substantial compliance. And it's really almost an economic waste doctrine. And it's not what we typically think of as substantial performance. Good enough is good enough. You essentially have to have delivered on time. You have to have believed in good faith that what you delivered, service, product, otherwise, was compliant with the contract's requirements. The defects have to be minor and have to be capable of correction in a short amount of time, and time has to not be of the essence. It's fairly rare for all of those conditions to be met. And importantly, all this provides is a defense against a default termination. It gives you an opportunity to correct those defects at your own cost. And that's why it's not substantial performance. So this is something that oftentimes companies that haven't done a lot of homework before getting into the federal market learn the hard way when they deliver, think they're done, and they realize, no, that they're not done. And if they want to be done, they're going to owe a significant amount of money back to the government, or they're only going to receive a portion of their expected payment. Let's go ahead on to the next slide.
Yeah, and I'll just comment that we have about 4 minutes left. So think about we'll skip some, but what are the key things you want to cover in the remaining time? Thanks.
Yeah, so let me spend a minute or two on unilateral changes, and then I think we can fast forward. So this really is, and let's talk about unilateral changes and terminations for convenience, because they're both aspects of the federal contracting that are very different from private commercial contracting. Unilateral changes, as I said, is the ability of the government to change the terms of the contract. And government contracts, we give the federal government the ability to do this because we believe the federal government's needs, contracting needs, are much more dynamic than private commercial entities, and therefore they need this flexibility in order to react in real time to the circumstances that they're contracting for. What this does is it allows the government to issue a change, and that could be both additive and deductive. It could increase the quantity, decrease the quantity of what it's buying. It can change other aspects of the work that is being performed. The government cannot unilaterally change the contract price, or it cannot unilaterally change a payment term or a warranty term or something like that. But it can change what it is contracting to receive, and it can, those changes can increase the cost of performance, they can decrease the cost of performance, and the contractor has to perform the work as changed, even if, one, the government believes that the contractor is only entitled to a small amount of additional compensation, or if the government doesn't even believe that it's changed the contract. The contractor has a remedy. It's a make-whole remedy. The contractor is entitled to recover the increased cost that it incurred because of the change, plus a reasonable profit on top of those increase costs. But if there's a dispute over whether a change has occurred and the amount of compensation the contractor is entitled to, the contractor has to perform the work as changed while that dispute is resolved. And that's a tough pill to swallow for some companies. Most companies would say, well, no, I've signed a contract to do X, Y, and Z. Now you want me to do A, B, and C. I'm not going to do that until you agree to pay me more money. If you refuse to perform the work as changed, you're subject to termination for default, which carries even greater consequences. Let me pass it back to Mike if you want to spend the last minute or so here on terminations for convenience. And thanks for having us. I'm happy to answer any questions about any of the slides I covered or any of the slides we were unable to cover. You'll have my contact information in the slide deck and I believe through the invite. So thank you.
And we'll also be distributing the slides to those who registered, so they'll be able to see the others. But Mike, do you want to take a minute on terminations for convenience?
Yep. So similar to the unilateral changes, this concept of terminating a contract for the convenience of the government is very atypical. It's not what you see in the commercial marketplace. So the government has a right to unilaterally terminate a contract at any time for almost any reason. A reason that I could think of that wouldn't be acceptable is, bad faith. So, I mean, the bar is very high to, make a termination convenience impermissible. The termination for convenience provisions, they allow contractors to recover their allowable costs associated with the termination. So, when the government terminates a contract, there's costs associated with winding down work. There's certain obligations that are stipulated in both FAR Part 49 and also the FAR cost principle related to terminations in 31205-42. There's obligations that the contractor has to undertake with regards to, transferring over inventory, winding down activities. There may be severance costs associated with terminating employees that were under contract. So the provisions, for terminations for convenience, while it gives the government broad authority to terminate the contract kind of almost at any time, it does provide for the reimbursement of costs for certain termination activities. And after termination to, get reimbursed for those types of costs, there's something called a termination settlement proposal that would be submitted by a contractor. And I think the big takeaway there is, you have an agreement with the government, it's bilateral. If that was in the commercial marketplace and somebody just stopped performance, that may give rise to litigation. Not so typically speaking in government contracting. It's, the government has the right to terminate for convenience. And it's written into the contract clauses. Again, unique concept in government contracting.
Yeah, thank you, Mike. Thank you, Dan. This has been excellent. And you've got for all the people in the audience, you've got our contact information. Feel free to email us or call us, and we can follow up on any of the things that were discussed here. And again, we'll be sending out these slides. Thanks again. Bye.